Hello, everybody. I am here with Professor Lisa Bressman, who was just featured on the top-cited environmental and administrative scholars list. Congratulations, Professor Bressman.
Thank you, Kristen. It's so nice to see you and have a chance to chat.
I am so excited to hear more about your work. Just to orient everybody, Professor Bressman is the Vice Dean here at Vanderbilt University Law School. She teaches regulatory state to our 1Ls and is a seasoned expert on everything administrative law. So let's orient our listeners. Professor Bressman, could you tell us what administrative law even is?
So administrative law concerns the creation, operation, and control of the power that federal administrative agencies exercise in this country. So think about all the alphabet soup: FDA, EPA, FCC, SEC. Those are our federal administrative agencies, those and much more.
Okay, so if I got this straight, you have Congress creating agencies. You've got courts interpreting what agencies do. And this is the area that you work in. It seems like a pretty broad area. Can you give me a bird's eye view of your scholarship specifically?
Now, my scholarship is more, I would say, abstract from the perspective of a law student. So I've done theoretical work on administrative law and the whole notion that democracy depends on non-arbitrary government action. So in particular, non-arbitrary agency action. I've done some theoretical work on the rules that the Supreme Court maintains to regulate itself. So we've seen a lot of discussion about ethics rules, for example, that apply to the Supreme Court. And my scholarship is a much broader brush look at the different sorts of norms that the Supreme Court has developed over time and has applied to themselves and in some cases departed from fairly recently. I've done a lot of empirical work. Empirical work is really close to my heart, even though I did not start out as an empirical scholar with empirical training. But I really wanted to know how these institutions operate, how the institutions I write theoretical work about actually do their jobs. So I did a big empirical study with a co-author on how congressional staffers draft statutes. So the people in Congress who help individual Congress members write the law, how do they go about that practice? And does what they do map how courts interpret statutes?
And Professor Bressman, what were your sort of key findings from that empirical study? Is it in fact true that the way congressional drafting happens does map well onto the decisions courts are making, or is there some sort of disconnect?
Yeah, I would say it's mixed. And again, every empirical study is limited in its ability to speak to with certainty how Congress, the big Congress, writes statutes, drafts legislation. But I do think by looking at those who are actually working on the language in the ordinary course, what we get a sense for is that some of the rules that courts apply track the rules that staffers apply, and some of them do not. So, for example, you might see that the Supreme Court depends heavily in recent days on dictionaries to define unclear terms in statutes, unclear words in statutes. Well, it turns out that these congressional staffers, they don't rely on dictionaries. Many of them don't even have a dictionary in their space when they're writing the legislation. Now that, again, no empirical study can speak conclusively to every single statute or every single member of Congress. These are staffers, not members of Congress. But again, there's an example of a kind of disconnect between how the Supreme Court, for example, might interpret statutes and how these staffers who have a hand in drafting legislation go about the task.
Professor Bressman, earlier when you were giving us that bird's eye view of your scholarship, you mentioned arbitrary or non-arbitrary agency action. What did you mean by that, and why did you write about that topic throughout your career?
And that's a really good question. So when I think about arbitrary action, I want to sort of circle back for us to think about how the government should look. What sort of a government do we want? How should it operate? And there might be a number of values or variables that we bring into that equation. So we might talk about accountable government, representative government. We might talk generally about democracy or democratic government. And we might talk about fair or equitable or rational or non-arbitrary government. And administrative law actually incorporates that concept of arbitrariness or non-arbitrariness in its sort of central law. So I sort of stepped back and I started to think about how well administrative law reflects that concept of non-arbitrary or rational law at a time when many scholars were focused on whether the law that agencies produce is accountable. So whether the president, for example, who's elected by the entire nation, has control over the actions that agencies take, that would make agency regulation, relatively speaking, accountable.
Right.
And I started to think about whether that value was the only one we should be discussing when we discuss administrative law. Now, I am by no means the first person to focus on arbitrariness, but coming at a time when administrative law scholarship was really focused on the accountability or the presidential control of agency action, I wanted to reflect on whether pursuing non-arbitrary, non-selective, non-biased action was a worthier, perhaps even better focus for our administrative law.
After you did that work and you made those reflections, what was your main, I suppose, argument or conclusion coming away from that work?
Good. So my conclusion, when I looked across administrative law and I looked across the decisions that the Supreme Court produced on administrative law, was that much of those decisions really focused on ensuring that agency action was not arbitrary. And that was an administrative law value, it was a quasi-constitutional value that really stood on par and in some cases exceeded the demand for political accountability or presidential control of agency action. And that in and of itself, I think, is interesting when you study a field and you see that the law is pointing in a certain direction, because it tells you something about how we, or at least how the Supreme Court thinks about how agencies should operate and the place of agencies in our government.
In this interview so far, we've talked about a lot of stuff. We've talked statutory interpretation, we've talked agency action, drafting, empirical work. I want to talk to you now a little bit about something very timely. It's been in the news. Of course, recently the Chevron decision has been overturned, and you've been in the news weighing in on this ruling, and I'd love for you to summarize what this landmark decision is and what it means that it's been overturned.
Let's talk about Chevron for a moment. So Chevron was a 40-year-old precedent in which the Supreme Court said that agencies interpret unclear, vague, ambiguous words in the statutes those agencies administer. In other words, put a different way, what Chevron says is that courts should accord a degree of respect or deference to agency interpretations rather than interpreting those statutes anew as if the agencies were not in the picture. So Chevron was a centerpiece of administrative law, in part because of its age, in part because it spoke to so many issues in the administrative state that by the time the case we're about to talk about came around, courts had relied on Chevron like 18,000 times. And agencies and parties had incorporated Chevron in their thinking about what regulations would look like. And my empirical study showed that there was some evidence that Congress actually drafted with Chevron in mind. So Chevron became a kind of embedded presumption that when statutory language was left ambiguous or happened to be ambiguous, that agencies would fill in the gap. In a case called Loper-Bright, the Supreme Court last term overruled Chevron, point blank, flat out. And in so doing, it unsettled an awful lot of agency law that had been settled for a long time. We still don't know what exactly the effects will be. But we do know that Congress and agencies and parties and courts will think differently now going forward.
All right, Professor Bressman, you're almost home free, but before we let you go, I wanted to ask you what you think the most pressing issue in administrative law today is.
Ooh, that's a really good question. So we got a number of big decisions, big administrative law decisions last term, and I think this term we'll watch and see what the court has to offer in understanding the scope of those decisions, particularly that Loper Bright decision overruling Chevron, but others as well. And so I think we're going to watch what happens to the rules of statutory interpretation. I think we're going to watch and see what happens to the arbitrary and capricious test. So there's that word arbitrary, and all of a sudden that might be front and center. It'll be an interesting term, and we'll all, students and other onlookers alike, watch and wait.
Well, we will all be on the edge of our seats. Thank you again for joining me, and congratulations.
Thanks so much, Kristen. This was fun.